All right, so the jury, please. All present, accounted for, Judge.
All right, proceed, please.
Does anybody need a writing instrument? Anything? Where everybody is set?
Welcome back home to my jury. You followed my instructions last night. Let me talk to you a little bit more about that. During the course of this trial, you know we've had a TV camera in here. We've had a photographer in here with a still camera. We've had print reporters in here. There's been daily reporting on various media sources of the events here. Both in the print, on TV, on the internet, probably a couple of blogs. Fortunately, I don't search that stuff out. I just want to be assured that all of you have followed my instructions and haven't seen any of those, inadvertently or otherwise, that have caught your attention or caused you to view them, watch them, listen to them, or read them.
No, sir.
No?
No, sir.
All right. Thank you. No positive answers, all negatives. All right, members of the jury will state and the defendant has now rested their case. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence. However, do listen closely to their arguments. They're intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has spoken. State, you may proceed.
Please support, counsel, ladies and gentlemen of the jury. Good morning. Good morning. Thank you very much. Let me move back just a little bit. We're a little close. Maybe too close for you. Ladies and gentlemen, on Thanksgiving weekend, November 2007, Sean Taylor was on top of the world. He was a National Football League star player, as he had been in college. He was home, in the comfort of his home, that he worked hard and long to earn, a home that he shared with his family, his mother, his sister, his brother, and Jackie Garcia. He had a beautiful family. And that evening, that Sunday evening, November the 25th, they were in their home, minding their own business, in their bedroom, in their bed. Sean, Jackie, their 18-month-old daughter, when a group of greedy men, including that man, from Fort Myers, drove 2.5 hours to that home to commit an armed burglary with a gun. This is how Sean Taylor looked when he went to sleep that night. And by the time the defendant had left with the people he traveled with, a day later, he looked like this. And that's not an easy picture to show, and it's not an easy picture to look at, but we're here and we're looking at it because of what he did. Because of what he did, he and the people that he traveled with, Sean Taylor was shot and he bled to death. And that's why we're here. Before I go on, I just want to take a moment or two and thank, on behalf of everyone, each and every one of you, for your patience, for your civic duty, and for your attention throughout these proceedings. I know that everyone appreciates it. It's not easy for you to be here. We've asked a couple of weeks of your time, not just a day or two, and you've all come. You've come and it hasn't been easy. And each and every one of us in the courtroom appreciates that. Let's go back to the beginning. This case didn't begin the day or two before November the 25th, when Jason Mitchell started the plan with the defendant and others to burglarize the home of Sean Taylor. It began on Sasha Johnson's birthday, back on October the 1st, that weekend. Sasha, who lived in the house, had a boyfriend named Devon Wardlow. And because she was generous, and because Sean was generous and didn't mind Sasha having her boyfriend there, her boyfriend would bring his friends, his friend Jason Mitchell and his friend Charles Wardlow, and family member Charles Wardlow, who, as we know, is one of the defendant's best friends. And Jason Mitchell was there that weekend to see Sean's generosity, to see how he lived, to see what his lifestyle was, to see what kind of cash would be around. And he literally saw $10,000 in cash that was given to Sasha Johnson. As time went by, Jason Mitchell believed there was a lot of money in that household. $100,000 to $200,000, a pot of gold, and he wanted to go steal it. And who did he bring with him? Did he travel all the way to Miami, where he had been before, by himself to get all of that money? Would Jason Mitchell or anyone else, and I ask you to use your common sense during the course of these discussions this afternoon, because it's all you need to decide this case. Would anybody bring someone like the defendant, somebody, as he claims, who wasn't in on it, to be an eyewitness to an armed burglary of a National Football League player's home, where they expect to pocket $100,000 to $200,000 and not get any of it? That doesn't make any sense at all. So they traveled there. The group of them traveled there to commit a burglary. And as they traveled there, unsuspecting, Sean and Jackie and their daughter were asleep in their bedroom. And when they arrived and they parked outside in the dark of night, they saw a bunch of cars. More cars than they expected. And we don't claim that they knew in advance that people would be in the house when they first got there, but they saw a lot of cars there and they went in anyway. And as they got there, this was the house and the wall they climbed over. The house that Sean purchased with his hard-earned money, that they traveled all the way to Fort Myers to break into. And they went around back and they broke into this door, the back patio door. And it took a while, as the defendant said in his statement. And the moment they did that, each and every one of them was guilty of burglary. Now, why did they bring a gun? Use your common sense, ladies and gentlemen. There is only one reason to bring a gun. It's insurance. It's for intimidation. It's for their protection. It's to do whatever is necessary, whatever it takes to get the money they drove all the way there to get. And so they break into the house. And even the defendant told you the tools came from his backyard. Coincidence? What do you think, ladies and gentlemen? At all times, I ask you to use your God-given common sense and look at the big picture of what happened here and the totality of the evidence. And as they entered that house with a gun, and there was only one gun, and it doesn't matter whether he had it or not, but he did, that was an armed burglary. And if during the course of that armed burglary, or the attempt to commit that armed burglary, a human being was killed, everyone who participated in that crime as a principal, helping each other to commit the crime, whether they're a lookout or a shooter or searching for the money, is going to be equally guilty of first-degree murder, as we'll discuss as we go along. So they look through the house, and at first, they don't find anything. And they hear a noise. And what do they do when they hear a noise? They get spooked, and so they go outside. They go back into the car. What car? The black Hertz rental car, ladies and gentlemen. That is a car that, regardless of whether he literally drove it off the Hertz lot, he knew about. He was there. He has been associated, by his own admission in that regard, with that car since the day it was rented by Rosemarie Johnson. Another coincidence, ladies and gentlemen? What do you think as you use your God-given common sense and you consider the totality of the evidence? They spread out through the house, they heard a noise, and they got spooked. So they went back to the car, and they sat in that car with that gun, and they talked about it. And you know what they decided, ladies and gentlemen? They didn't come all the way there. It's not to Miami and back. It's not around the corner and back. It's a 2.5 hour ride each way. They were greedy. They wanted the money, just as he said in his statement. And it's as simple as that when you get right down to it. And so they went back in. And they believed at that time that the money was in the master bedroom. So they approached the master bedroom door. By now, Sean Taylor has been awakened. And he's worried. He has a machete in the house that he uses for lawn work. And he picks it up to protect himself and his home and his girlfriend and his daughter, as he is permitted to do by law. He says to Jackie, call 911, and she's understandably petrified, as anyone would be. She's in the bed under the covers with an 18-month-old daughter. As Sean approaches the door, he kicks it in. And at that moment, he sees someone there. Now, I'm not going to stand here and tell you that he knew right that second it was Sean Taylor. I don't have to prove that he knew that right this second. But use your common sense, ladies and gentlemen. He's in the master bedroom. He scoured the house. There are a lot of cars there. He sees someone out of the corner of his eyes with something in his hands, and he shoots the gun that he brought there. That's what the gun was for, ladies and gentlemen. He shot Sean Taylor, and Sean Taylor fell to the floor, mortally wounded, and immediately began bleeding to death. So what does the defendant and what do he and his friends do at that point in time? Do they, as Jackie did, stop and apply pressure to the wound, try to help him, call 911, any of those things? No. They run for their own lives to save their own skins. And in order to get out fast enough, because they just don't care about anyone in or around that home, they shoot out the sliding glass door. Now, fortunately, no one was there. But just as someone was behind that master bedroom door, anyone could have been there, trying to get out the back to save their lives. But they fire and shoot out the sliding glass door in a residential home so they can get out. And they do get out. Some of the cars they saw, the door that was pried open, the master bedroom door with a herringbone print, the bed in a home where Jackie and Sean and their daughter were asleep minding their own business. And as they ran, Jackie got up and called 911. And this is what she saw. Sean's not there now, not in this picture, because the police had come and fire rescue had come as she tried to apply pressure to save Sean, but she couldn't. Nobody could. They had killed him. And as he lay there bleeding to death, they were on their way back to, Fort Myers. In this car, the car, for which he was present when it was rented. And this photograph, taken at SunPass, the police didn't have this before they interviewed him. This is some of the information that he gave them about the car, and they're coming back and not paying a toll. That educated them to go and look. Something they learned from him. The motor box, electric box, and motor box cover that the men jumped down on as they climbed over the wall to break into Sean Taylor's house. When crime scene arrived, it's hard to make out here, but I know that you all previously looked at that herringbone print on the box cover one at a time with the flashlight, and you could see there are some different patterns, but one of them is consistent with a Nike that crime scene had processed that was blown up. And you can see the NI and the other letters to the Nike shocks that crime scene photographed and John Mancini later processed and formed opinions about. There's that dot pattern that came from Jason Mitchell's shoes that were recovered. There's the Nike pattern. There are other patterns. And the police didn't come in here, nor did their crime scene technicians, and make bold, unsupported claims like, these are definitely the shoes, these are definitely this, these are definitely that. I submit to you, and you use your common sense, you saw them, you judged their credibility, they told you what they found and what it meant. And when you look at the big picture, it becomes clear. So the defendant and his friends are on their way back to Fort Myers. And they go to the home of Ariel Boston. And what do they do there, ladies and gentlemen? Does the defendant start confronting them, saying, how could this, how could this happen? What happened? Is he yelling at these people? No. Ariel Boston says they're having a great time. Benja Hunt, Eric Rivera, Jason Mitchell, Timmy Brown, and Charles Wardlow back in that room by themselves. They're enjoying themselves, and they brought tools, she later discovered, that she gave to her uncle, who in turn gave them to Detective Segovia. And the defendant himself admitted to you, those were tools that came from his yard, tools that he says other people used to break into the house of Sean Taylor. Is it all coincidence, ladies and gentlemen? The car he was there for, the tools from his yard, he's there with his best friend, phone calls back and forth among all of them, Mitchell, Wardlow, the defendant, is all that a coincidence? And you saw the picture of the defendant's family, but it was a nice picture, but he wasn't with them that night, ladies and gentlemen. That's the defendant, right there, over there in that picture, about to take an oath to swear to God to tell the truth to the police on November the 30th of 2007. This is how he looked when Ariel Boston saw him. These are the people he was with when Ariel Boston saw him, not his family. These people he helped to commit an armed burglary and a first-degree murder. So he was at Ariel Boston's house for a while. Then she says they left. She's back in her room. She's minding her own business. She knows these people. They must know each other. Use your common sense. They're all there, and she knows all of them. He says he left and took the car and came back again. He could have taken that car anytime he wanted. We'll talk more about his testimony to you the other day. He could have done whatever he wanted with that car. He takes it and leaves with it when he wants to do so. But he left Ariel Boston's house, and do you know what he did, ladies and gentlemen? He went on with his life. While Sean Taylor died, he hung out with Charles Wardlow. He hung out with his blood relatives, Jeremy Gabriel, Devon Mays, who's a convicted felon now. That's what he did that week. And he was still with Charles Wardlow when he was stopped. So what are the police doing? They processed the scene. Unfortunately, ultimately, they did not find DNA from any of these people in the house. But the defendant himself admits 3 of them were in the house. So just as the expert told you about DNA, the fact that one's DNA is not found someplace does not mean they were not there. He admits he was in the car. He admits Hunt, Mitchell, and Brown, he says by themselves, went inside the house. And so at the end of the day, ladies and gentlemen, it's exactly as the expert told you. And the same is true of latent fingerprints. He admits people were in the house. Obviously, someone was in the house. The fact that they did not find his fingerprints or their fingerprints does not mean that they did not commit an armed burglary in which Sean Taylor was killed. And he basically tells you that himself. So the police start to investigate. They talk to Sasha Johnson. They hear about people who have been there before, like Mitchell and Wardlow. They get a tip. They get a tip that people from Fort Myers were involved. And it includes him, the defendant. Is that a coincidence, ladies and gentlemen? The fact that a tip that they got is consistent with telephone records, including a ping from the cell site dump from Mitchell and Wardlow right by Sean Taylor's house around the time he was killed. Is that all coincidence? So they have gotten this information, or much of it. They have his name. They have other names. What do we expect them to do? They're investigators. As we discussed previously, they're not investigating an overdue library book. They're out of their jurisdiction. They talk with the Florida Department of Law Enforcement, which is the largest law enforcement agency in the state of Florida. They can go anywhere they have to go and have jurisdiction. In case someone they're looking for moves from one county to another, they drive away, they cross county lines.
Overall.
The witnesses told you that they contacted the Florida Department of Law Enforcement, for a number of reasons, including the fact that they have statewide jurisdiction. And they have a meeting with them at their facility. Now, when they pick that facility, they pick Florida Department of Law Enforcement because they have worked with them before. What a surprise. The largest law enforcement agency in Dade County, Florida, with the largest law enforcement agency in the state of Florida, has worked together before. They don't just enlist the aid of the Florida Department of Law Enforcement. They have other people from other departments there, and they have a briefing. And they say to these people, because they want to investigate properly, they want to investigate, they want to talk to these people, but they say to them, it's 4 days after the crime. We have some leads. We want to follow up on them. Please assist us and go out in the community and see if you can locate these people. Ideally, we would like to have them come in and talk with us at about the same time. That is what would be ideal. Don't arrest them. Don't handcuff them. Don't force them in. If they are not willing to come in, walk away. It has only been 4 days. We will continue our investigation professionally and do what we need to do. And whatever happens from there happens. And so they start looking for all of these people. And the first ones they find are the defendant. And who is he with? Of all people, the guy whose phone pinged off the tower by Sean Taylor's house the night of the murder, Charles Wardlow, and his 2 blood relatives. This further corroborates the tip. So even though they didn't want to arrest him, that doesn't mean they can't stop a car that these people are in. This doesn't mean they can not detain them and ask them if they are willing to come in voluntarily. And that's exactly what happened. You heard from the officers who were there. Officer Olson, Special Agent Walsh, who's now with another department, Sergeant Gonzalez. These people pulled up in a marked police car because they wanted the people in the car to know who they were. The people in the car at that time thought it was a routine traffic stop. And they walked up, as Art Gonzalez did. He asked the driver for his license and registration, said he was going to go back and run it. Mike Walsh walked up to the passenger side window and made him. He saw him, the defendant, and he saw Charles Wardlow, and he walked back to the back of the car. There was a discussion. It was decided to ask the people to come out one by one, come back, and Mike Walsh would talk with them. And he would ask them, are you willing to come back to the Florida Department of Law Enforcement? There are some people who would like to talk with you, and talk with them there. And the people agreed. And he agreed. And he went. So you heard from officers from 2 different agencies, not the Miami-Dade Police Department, about what happened and the circumstances surrounding the stop of that car. Why do they want to talk to these 2 other people? Well, why wouldn't they want to talk to these 2 other people? They don't know who was actually at Sean Taylor's house for sure. They haven't talked with anyone yet. If Eric Rivera and Charles Wardlow were there, who knows what they said to these 2 people in the car, so why wouldn't they want to talk with them? So they ask them, the keys are stuck in the ignition, you hear initially. They drive the car back, and the people agree to go. What version do you hear from the defendant's family? And you determine their credibility. Everyone they could see got handcuffed according to them, including themselves and Charles Wardlow. They claim they didn't see Eric Rivera. The defendant himself says he was never handcuffed. If they're not going to handcuff him, why would they handcuff anyone else? It doesn't make any sense. It is not true. Nor does their claim, that is the cousin's claim, that they were brought back to the Florida Department of Law Enforcement where one of them fell asleep, according to him, if you can believe that. And they were detained there until 8 o'clock or 9 o'clock at night. Why would they be detained there until 8 o'clock or 9 o'clock at night? The defendant himself tells you he's calling Charles Wardlow before 4 o'clock. His father has come and gone. The cat is out of the bag, if the cat was ever in the bag, and it's not true. Why would they take their cell phones? One of them claims he had a cell phone, but it didn't even work. When they let them go, when they walked away from the Florida Department of Law Enforcement, it had to be early in the day. They could get in their car and drive to any phone. The whole thing was a fabrication. So the defendant comes back. No one has taken his phone. You've heard testimony from the defendant from not just the witness stand, but another hearing that he participated in. First he says, Officer Olson took it and I never saw it again. You heard from Officer Olson. He didn't take his phone. Then he says, well, Officer Olson took it and then Officer Gonzalez gave it to Detective Segovia, but he originally said he never saw it again. And it doesn't matter how someone else may try to explain it. That's what the testimony was at the hearing that you heard about. And now, having reviewed the cell phone records the other day, right before he testified, he realizes, uh-oh, I have my phone and I'm still making calls that night. And so now he wants to say they gave it back to him. So you think about those things when you're thinking about his credibility and what's the truth. Because the truth is he's guilty. He admitted it under oath. And he admitted it in court, though he denied it yesterday. And that's the truth, ladies and gentlemen. So he's back at 11:41. He's introduced to Detective Segovia, who's in plain clothes, casually dressed. And Detective Bellew, you met him, you saw these people, you had an opportunity to observe their demeanor, the way they speak, the way they act, the things that they said, how they said them, to consider it in the totality of everything else that you heard. After taking all this time to have him come back, they want him to talk. They advise him of his Miranda rights. They tell him that he's free to leave. Oh, and by the way, ladies and gentlemen, he admits he knew and understood his Miranda rights. So that's not an issue. So he's told he's free to leave. There's no law that requires the police to notify the parents of someone like him, who was 17 years old in 8 months, and as you now know, pretty streetwise, if they're there voluntarily talking with them. And so they talk with him. They say, you're free to go. They let him call his parents if he wants to do so. He doesn't want to do that. By 11:56, he's gotten his Miranda rights. That's around 12 o'clock in the afternoon. And the first thing he does is he lies. He lies and lies and lies and lies. And yesterday, when you heard him testify, you have every right to believe he lied to your faces. You're all intelligent people from the community. You've all got common sense. You've all been around. You're adults. So they're trying to ask him, has he been in Miami? They don't want him to get up and walk away. They're not going to confront him. They're not going to yell at him. They're not going to knock over chairs to get him to clam up. If anything, they're going to be nice. They're going to be polite. They're going to try to keep him talking. And that's exactly what they told you that they did, and exactly what your common sense says that they would do. Steve Emerson, you met him, you saw him. There's a landline in that office. He doesn't hear any yelling or screaming. It's a large conference room. His cell phone is on the table. The landline is on the table. He admits himself that the officers were in and out. Do you think, ladies and gentlemen, that in a conference room next to an area where people from Fort Myers Police Department and the Florida Department of Law Enforcement, people who could be coming and going and milling about, are going to be pounding the table and knocking over chairs and yelling at him? That defies common sense. It doesn't make any sense. And that's why, as we will discuss later, he tried to make it better, more palatable, something that you might find more intriguing to swallow, to help himself get away with murder. So they talk with him for a while. He denies going to Miami. It's only 4 days before. He denies knowing Jason Mitchell, that he went to Miami to burglarize Sean Taylor's home with. He denies a lot of things. By 12:10, they take a break. They want to get information. They know Charles Wardlow is there. They know Jason Mitchell is there. Other people are talking with them, and they give him an hour to think about it, and they get up and they walk out of the room, and they offer him a break. And he can sit there and think about it. And then when they go back in at about 20 after 1, they tell him that some things have been inconsistent in what he has said. And they ask him to think back and try to remember. And he starts to say, well, maybe it's a little fuzzy for me. And I don't want to say something, if it's a little fuzzy and then get myself in trouble. So as he admits to you, he's blowing smoke in their face. He's playing them. He's using them. He is delaying them. So they listen to it for a while, and they say, well, you know what? We're going to go ahead and we're going to check with your parents. And he has told them they were at the movies. Do you think the detectives would make up that he said he was at the movies or hanging out with his family that weekend, that he denies on the witness stand when he says he could remember everything that happened during certain days? And he snaps at them and says, if I wanted to call my mother, I would have called her. And so they continue to talk with him. And then something very disturbing happens. He's starting to get nervous, but he hasn't said anything yet. It's about 1:56. They've only been talking with him for about an hour. And Detective Carmody, who later went to Jason Mitchell's home at night on December the 1st, walks by with Jason Mitchell. And you know yourselves from what the defendant said that a statement is made, your buddy's talking. Buddy's talking to us. Well, now the jig is up, ladies and gentlemen. This has nothing to do with some bizarre claim that people are going to get his mother or people are going to go and raid his house. He's not even been arrested yet. They're still just talking to him. There's no one coming to get him. No one said anything was wrong with his mother. Do you know what was wrong, ladies and gentlemen? He's caught. Jason Mitchell is standing right there with Ed Carmody, not Larry Bellew. Larry Bellew's in the room with him, about to say something to him that finally gets him to start to tell the truth. And so when Jason Mitchell walks away, he's getting more and more nervous. The detectives tell you that he starts rubbing his hands. He's looking down. They're saying, look at me. Look me in the eye. Your common sense tells you why that is. It's not easy to look someone in the eye and not tell the truth, is it? Larry Bellew sat on the witness stand, a retired, experienced detective, and looked at you all in the eye, and you judge his credibility. And he knew the defendant was on the verge of coming clean. He could see it. He could sense it. He could feel it. And he knew that the defendant may have a hard time coming out and admitting what he did. to Sean Taylor, shooting him and killing him. And so he said to him, look, and I'm not going to quote it, but he basically said, Sean Taylor was a National Football League star. He was in his home with his wife and his daughter minding his own business, the home that he worked for. When some greedy people, but he didn't say it precisely like that, he wasn't a drug dealer, he was a hero to youth all over America, and people who were too lazy to get a job came over and preyed on him. The family were good people. They weren't criminals. And it's understandable that you may have a hard time coming out and verbalizing what you did. If you did it, if you were involved, just nod your head. And he did. He nodded his head. And from there, a weight was evidently lifted from him. He knew Mitchell was there. He knew the jig was up. And the detectives asked him details about what happened. And he began to tell them what happened. And one of the things he said was Devon wasn't there. He wasn't involved. Now, why would the detectives make that up? Why would they want him to say Devon wasn't involved when it's only 4 days after the crime? Obviously, they're telling you the words that came from his mouth. He talked about how they had gone to Miami, how they had planned it, how there were a lot of people there who had gone, that they planned to get a lot of money, that they didn't expect to have anyone home, that he drove there, that Charles broke into the back door, that they were in and out, that they went back in because they had come for the money. And they decided to kick the door in, and he is the one who kicked the door in. That's what he said to them then. And all of this, ladies and gentlemen, is happening before 2:15, when he hand draws this sketch. Do you really believe that they're sitting there feeding him a lot of information? He tells them things they don't even know. The SUV, the rental, Ariel Boston. He's drawing diagrams. He's identifying people they haven't even picked up yet. So now they can be sure they're the right people. He's talking about shoes that he wore. All of this after about 1 hour. Use your common sense, ladies and gentlemen. Do you think that this man decided, well, I know I'm going to jail, so I'm going to confess. So the first thing I do isn't going to be to say I did it. It isn't going to be to say I didn't mean it. It isn't going to be to say I didn't realize it was Sean Taylor. It isn't going to be to say I didn't shoot him in the heart. I just fired. It isn't going to be any of those things. What did he tell you was the very first thing that he did? To pick up the phone and call Charles Wardlow and say, hey, Charles, say I did it. I shot Sean Taylor. I mean, what sense does that make to you, ladies and gentlemen? So when you're thinking about everything that he said, none of it makes sense. None of it rings true. Because he actually did confess to the murder that he committed. Let's take a moment and look at just a couple of excerpts of the defendant talking to the police, so that you could see with your own eyes and your own ears what he said on tape later. Now, I know the defense is going to come up here and they're going to say to you, well, why didn't we have a tape recording earlier? That has been explained to you, ladies and gentlemen. First and most importantly, there is no law. You will hear no law that says the police must tape record any conversation. Nevertheless, an initial conversation. The police followed what their office policy is. Nothing special was done to him or about him. He was treated like any and every other Miami-Dade Police Department suspect, the largest law enforcement agency in the county that investigated hundreds of homicides before, bless you, and after that homicide. What would happen if a tape ran indefinitely? How long will the interview last? There's no time limit on how long they can talk to someone who's willing to talk with them. What if there are breaks? Camera keeps running. What if he has to go to the bathroom? The camera's running. If it's wired in a room, are people supposed to follow him around in the bathroom with a camera? I mean, don't you think the moment something isn't on video, a claim will be made, that's the moment it happened. That's when they said it was my mother. So they treated him the way they treat anyone else. They did not do anything illegal. So let's look at some of the things that he says. The first thing he says when he was placed under oath and gave a confession is he raises his right hand and he swears to God he's going to tell the truth. Well, there you go, ladies and gentlemen. He sat there and he took an oath and he swore to God it was the truth.
Who was driving?
He says he drove. They don't need him to say he drove if he's going to say he shot. He's just telling them what happened.
So he was one more, I assume that he shot the room. And everybody didn't visualize where that was the room. I was going to a right, then that right. And that door was closed. It was closed. I was on lock. When that opened for a moment. What I found. They told me to keep in. Who took the ticket? Me? At this point, where are you standing in the hallway? In front of the door. Where's everybody standing? Right at the bottom. So you right or you left? All right. And the 5 minutes we were there all around? Yeah. No, Charles was on holiday. Where was Charles? He was the one that was from me. Inside the house? Yeah. Like going to the room? Yeah. What were the lights inside the house? It was dark, it was very light off. Who turned the light on? Turned the light on. So what is the next? Keep going. How many times did I keep the door open? Once. And immediately you kick the door. What happened? I looked at the name and said, "Look at money." And then I looked at it. And I cornered my eye and I feel something in his hand. Did Sean Taylor say anything to you? No. Did you say anything to Sean Taylor? No. Did anybody say anything? Did you know that Sean Taylor was there? No. Now what happened then? Everybody ran it. And what did you do? I ran. Before you ran, what did you do when you saw Sean Taylor? I didn't know it was
his demeanor. Look at the way he's explaining it.
When you
Use
kick
your
the door,
common sense.
were you holding on the gun? Yes. You told our son the whole time we're out. What was the gun the whole time? You said it was over your hand? Yes. You were holding on to the gun the whole time? Where did you get the gun? Where's the brother's name?
Look how he hesitates there. Not wanting to know where he got the gun.
Yes, so you Magnolia? You just buy the gun here? I was grabbing off. You know the date?
Police don't care what color it is.
How long have you had that gun? Did you buy it from him? Did he give it to you? He gave it to me, no. What made you take the gun? So now you say you keep the door and you shot the other standing there, running at you. You can't see my place with the brother. No, we got 80, not 20 miles, you know, running. We're like a 2 feet away. We're like in the can, it's not bad. You say you got something in his hand. Do you know what he had in his hand? No.
You notice they didn't get him to say it was a
How many shots
machine.
did you shoot him? One. Do you know where he shot him? And how quickly did he go down? Did you say anything after he went down? No. And when did you go after that? Which way did you go out? We got going back. How did you go with that right door? Did you shoot that glass door with the intention of getting away from the house? Did you shoot the door in order to gain access to exit the house? And what did you want from there? To find the window that
Then he talks about the diagram.
And earlier today, you also showed me the diagram. The diagram that you drew, where you indicated the wall, the house, the pool, the way you gained the entry to the house, and where you were standing in comparison to what Sean Taylor was standing when you shot, and the way you exited as well. Do you know the diagram you drew? And is that your signature to the diagram too? Yes. And you read up the date and time for me, please.
Does he sound forced? Does he look forced?
Has everything you stated been true and correct and let you knowledge? Yes. Anybody correct before anything anywhere possible? No. Have you made the statement freely and voluntarily? Yes.
So, those were his statements under oath on video on November the 30th of 2007. So, you need to think about that. The fact that that's what he said, what he personally said. When you think about the big picture of the case. Let's talk a minute or two.
you've got up there now is a demonstrative aid for the state in presenting their summation to you with a closing argument. That blow-up is not, and that exhibit is not in evidence. You will not have that. That's to assist the state in their closing argument.
I'm also showing you the letter. So he's arrested, he's in custody, and he's starting to panic because he knows that he did it and he knows he confessed to it under oath. So he writes a letter to his good friend Jairus, the one he called the night of the murder, the one, when his father did come to the station. First of all, the police did notify his father. They began to contact him as soon as he nodded his head. They gave him a ride. They did give him directions of where they were or the location. He hesitated in his statement. He was in no great rush to get there. He never called him on his cell phone. And what happened when his father got there? Well, to begin with, according to the defendant himself, it didn't make any difference because he was already cooperating. He was cooperating before his father got there. He was cooperating after his father got there. And according to the defendant, when his father got there, he was mostly interested in getting his phone and calling his good friend Jairus. So now back to Jairus. He says to Jairus, it's up to my lawyer to cross-examine witnesses and make them confused. I already have an alibi. And he's trying to get Jairus to help him to subvert justice, to avoid being held responsible for what he did, to try to get Ariel Boston to come in and give a story, not the truth. He's worried that Tim's turning state's evidence on him, and he knows that Tim knows what he did. He's worried about other things. He tells Jairus to tell Ariel that if she fucks with his people, with the defendant, they will fuck with her and hers. Now, what do you make of that, ladies and gentlemen? And at the end of the letter, he says, burn it, just like he burned his shoes. That's his verbiage. Let's take it a moment or two and take a look at the law. The first thing that I want to talk with you about is the law of principles. If the defendant helps another person or persons commit or attempt to commit a crime, he is a principal and must be treated as though he did all the other things the other persons did if he had a conscious intent that the crime be done, and that crime is the burglary for felony murder, whether or not he's the shooter, and he did some act or said some word that was intended to and did indicate, cause, encourage, assist, or advise the other persons to commit or attempt to commit the crime. He doesn't even have to be there when the crime is committed. Now, just being at a location when a crime is committed, minding your own business and doing nothing doesn't make you a principal, but if you're doing something to help the commission of the crime, you are. Whether you're a lookout, or you're a planner, or you provided the tools, or the money, or you did the shooting, or any of those things. So an easy way to consider the charges here, because you first consider whether the highest charge has been proven beyond a reasonable doubt, is to look at the burglary. What is the essence of a burglary? Entering a dwelling, the defendant or someone that he's a principal with the intent to commit a crime. In this instance, a theft. Can there be any doubt that that happened in this case? So you're going to be hearing instructions about what are called lesser included offenses. Let's say somebody entered Sean Taylor's house and they didn't intend to commit any crime. That would be a trespass. So you're going to get an instruction about that. But because there's no reasonable way to view the evidence as being anything other than the home was entered to commit a theft and then it's a burglary, you don't need to consider trespass. It is a burglary. The only issue is, did the defendant do it or is he a principal? And the law of first-degree felony murder is, if during the commission or attempt to commit a burglary, death occurs as a consequence of Rivera, and the law of principles applies to everyone, including felony murder, that is felony murder, that if death occurs while he's engaged in the commission of a burglary, while he's attempting to commit a burglary, that he's the person who killed Sean Taylor, or he's killed by a person other than Eric Rivera, and they're both principals in the burglary, that he is guilty of first-degree murder, and it does not matter whether he intended to kill the victim. It does not matter whether he had premeditation. All that matters is that the victim was killed during the course of the burglary, and we know he was killed by one of the burglars. So you're going to get verdict sheets to consider, and they can be a little complicated when you go back to the jury room. And they're going to make you, or ask you to make some decisions in the case about whether the state has proven the case beyond and to the exclusion of any reasonable doubt, not a speculative doubt, not a maybe type doubt, looking at the totality of the evidence in the case. So when you look at burglary, and the same will be true of felony murder later, if he's a principal in an armed burglary, and that's proved beyond a reasonable doubt, you would check that off right under count 2. Then you make decisions about what you believe he personally did. And we talked about this in jury selection. If you believe that he's the person who discharged the firearm, you would check that box off, which the state has proven beyond and to the exclusion of any reasonable doubt. If you believe, then there are these lesser included boxes, like, do you believe he was in possession of a gun but he didn't fire it, or he fired it but it didn't cause death or great bodily harm? So obviously that first box applies, and then you make other decisions by way of boxes.
Mr. Rubin, can I interrupt just for a second? I've got a client who's got to leave to catch the bus. I didn't want them doing it while you were talking, so if you can give me 2 minutes for them to get up and exit quietly, then I'll let you continue. Any of these folks on filing out want to move over to some spots that are open and available. Help me some.
All right, so we were talking about these boxes for a moment, and was an assault or battery committed during the commission of the burglary? Well, if it's a battery to hit somebody, when you shoot them and kill them, it's a battery. So you would check that box off. Was there a human being inside the structure? Well, you would think that you wouldn't have to make a decision about that, but you do, and that's an easy decision. The same is true of first-degree felony murder. Is he a principal in first-degree felony murder? Was he a principal in the burglary? Did the victim die? Guilty of first-degree felony murder. Then you make decisions. Is he the person who fired? Just like with the armed burglary. And you check off the box that you believe is appropriate based on the proof that you've been provided. So now let's take a moment and just look at the big picture, ladies and gentlemen. And what you see is a picture of a guilty man. A man who's been proven guilty beyond and to the exclusion of every reasonable doubt. A man who was involved in when the SUV was first rented, a man who was there. Why is he always just there? What a coincidence. A man who started out in Fort Myers. You can see the trail of cell phone calls, which are in evidence on another exhibit, as he and his friends go across Alligator Alley into the home of Sean Taylor, where they murder him. And that's not a photograph in evidence. It's a demonstrative exhibit. It's a slightly different view, but you'll have a photograph. And then they flee back and have a good time in Ariel Boston's house, and she sees them. They pass the sun pass, and he wants you to believe that he's got $200 in his pocket, but he's not going to give them a little money for a toll or a couple bucks for gas. Do you know why he's saying that? That's a convenient, contrived lie, so that maybe you won't find him to be a principal in the crime. Use your common sense, ladies and gentlemen. They go back to Ariel Boston's house, so there's Sean Taylor, who's minding his own business, and he's dead now. There's the footprints that he left. There's the shoes that he personally identified at the police department just after 2 o'clock. That is Ariel Boston's house, you know, where the letter was sent to Jairus saying, get rid of her, I have an alibi now. That's what I'll present to try to get away with murder. And then he gets caught, he gives a statement, he swears to God to tell the truth, and the truth is he shot Sean Taylor. That's in the statement. You just heard that. And he swears to God that statement is true and correct. Nobody threatened him in any way possible. And that, ladies and gentlemen, when you look at the big picture and you use your common sense, is proof to the exclusion of any reasonable doubt. Thank you very much for your attention.
All right, members of the jury, we're going to take about a 5-minute break before we proceed on to defense's closing. Just to stretch a little bit before you can stretch your arms. So the defense has an opportunity to move things around a little bit before they start. Yeah, if you'll assemble a rough answer to in about 5 minutes. I can take it 10. We can't do anything in 5 minutes.
All right, ladies and gentlemen, just float your tablets down on your chairs. Take your personal belongings with you. We'll meet you in 10 minutes at the other end of the hallway.